Kick ass.
Welcome to Kick Law School's Ass, where our goal is to help you cut through the confusion of the 1L year and beat a path straight to the top of your class. One of the more common questions 1Ls have during the first semester is, what exactly do I do to brief my cases? I mean, what really is a case brief for that matter? And in this series of videos, I and my friends at Kick Law School's Ass are going to help you learn exactly how to brief your cases and how to brief them well. As you'll discover, though, it's one thing to tell you what a brief is, and another entirely to teach you how to write one or create one for law school. Skills are just kind of like that. The best way to learn them, to acquire them, is to practice them. And that, incidentally, is what we're going to do through this series of videos. And there are going to be more than just this one. But let's talk for a minute about what this sort of introduction to case briefing will cover. We're going to talk about what a case is out in the real world. We're going to talk about what a brief is out in the real world, and an order and an opinion. And depending on the time, hopefully this video will be short enough, concise enough to get to this content as well. We're going to talk about what a case and a brief in law school are, because those aren't quite the same things, technically speaking, as what you encounter when you enter practice. Generally speaking, we will also talk about how you should go about briefing whatever assigned reading you encounter based upon your syllabus in your first year subjects. In subsequent videos, we're going to brief a few cases in real time together using some practical examples from an actual tort law casebook. When we've worked a few example cases together, we'll talk about how to knit those cases together into an exam-suitable outline of the subject. Now, we're going to start with an easy subject, tort law, just to kind of get your feet wet, and we may go from there to more complex or technical subjects like civil procedure or constitutional law. It just really depends on the level of exposure we feel like you'd benefit from and whether there's a reason to advance the concept forward through different subjects. So, with that said, let's jump into the content proper of this video. And the first term that we need to talk about in a real-world sense is, what is a case? And in the real world, a case is the overall label for a formal dispute between at least two parties that a court will have to resolve. So just bear with me here for a second. I'm going to give you kind of a timeline of a case. And you always have to make the line on the right, not the left for the camera. I always forget that. So let's say that you got two parties who have a dispute that they cannot resolve between themselves, all right? Just for the sake of illustration, let's say that there is a medical malpractice case that a former patient or the relative of a former patient has against a doctor. Maybe the doctor operated on the wrong limb or paralyzed his patient or something like that. Well, what will happen is that the patient will be a plaintiff in a lawsuit, and they will file a lawsuit with the local trial court. Typically, the document that they file is called a complaint. When they do that, the case starts running. And ultimately, that case, if the parties don't settle it, will proceed to trial before a jury or a judge. And depending on who decides the facts of the case, there will be a verdict. Once there's a verdict, the trial court will enter a judgment on it, either saying, you know what, there's nothing here, and dismissing the case, or saying, we have found that this doctor did in fact commit medical malpractice and that he damaged the client in the amount of, and I'm just using this as an example, $2 million. So we therefore order him to pay that to his patient. Now maybe the doctor is dissatisfied with aspects of that trial, and so he wants a redo. Well, in that instance, what he will do is he will appeal from the judgment of the trial court and go the next level up. He will go to a court of appeal and he'll say, hey, the trial court should have let evidence in that it didn't. It should have altered the jury instructions. It should have kept evidence out that it let in. Here are all these things about the trial process where the trial court got it wrong. Court of Appeals, you fix it. And maybe the trial court will agree, or maybe it'll disagree. But either way, if the doctor or his patient are dissatisfied with what the Court of Appeals does, then they may say, you know what, we need to go to the Supreme Court. Maybe the state Supreme Court if they're in the state system, or the United States Supreme Court if they're in the federal system for some reason. At any rate, At that point, if the Supreme Court says, all right, we're going to undo everything that's come before and we're going to start this case over from the beginning, then the whole process starts over. If, on the other hand, they say, you know what, the verdict at the trial level was correct, we're upholding that judgment, this case is over, boom, the case is done. But the word case refers to that entire proceeding at the trial court level, at the appellate court level, at the Supreme Court level, as applicable. So, one thing I want you to see here is a case is not necessarily actively fought the entire time that it exists. There can be long periods of time where it's dormant. And the reason why that's important is you're going to hear a term thrown around a lot in the real world, litigation. And litigation just means active fighting. It means that there is actually something the parties are wrangling about at the particular moment. So a jury trial is really the ultimate expression of litigation, but it is not the only time that litigation occurs. You obviously have appellate litigation where we file documents making formal arguments based upon the facts and the law and appear before the court and make oral argument. You have litigation at the Supreme Court level in the same ways. But one of the biggest sources of litigation is between the trial and filing. There's this period in here called discovery where the various parties are asking the others to give them evidence. Maybe the plaintiff in our medical malpractice action is saying, we want particular internal reports that your credentialing hospital made about the treatment that this patient received. And we want you to give those to us. Maybe the doctor is saying, no, those are privileged for one reason or another. Well, you can have litigation when the plaintiff files a motion with the court asking the court to compel that doctor to cough up those records. Maybe the doctor makes his own competing motion with the court and says, we want an order of protection. Tell them specifically that they may not have access to this body of documents. Well, any discrete, little mini fight that occurs, that's litigation. So I just want you to be aware, the case, it can lie dormant for months at a time while the lawyers are sort of combing through the evidence that they've got. But litigation is when they're actually fighting over something. At a trial, obviously, they're fighting over the version of the facts that they want the jury to embrace. But there are plenty of opportunities for fighting over particular discrete issues in the life cycle of that entire case. So in the real world, a brief is a document that makes an argument relevant to a litigated matter. So at the trial level, this is typically a memorandum of law written in support of a motion before the trial court. If you remember when we were talking about our discovery dispute, the plaintiff says, we want this report, and the defendant doctor says, no, you're not entitled to it, I'm not going to give it to you. The plaintiff will make a motion, and the motion is a formal request from the court, hey, make this guy give me what I want, right? But what accompanies that is a fuller explanation of the law and the facts and why they justify that request, okay? So at the trial level, you're going to get a motion and a memorandum of law. That memo is what's referred to as a brief, and that's at the trial level. On an appeal, a brief is a much more in-depth, formal, written argument detailing, for example, why a lower court's overall disposition or ruling in the case should either be upheld or overturned. So you get appellate briefs, you get Supreme Court briefs, but those are far more robust and holistic presentations of their argument than memoranda and briefing at the trial level tend to be. At any rate, so what you're going to get during litigation is you're going to get briefing in the form of memoranda of law supporting motions. That is, the arguments supporting requests for particular things, particular rulings from a judge. And in the real world, anytime you've got a motion, anytime you've got anything litigated, anytime you've got anything that needs to be resolved, then the court will have to issue an order to dispose of that litigated matter. Now, if it's disposing of an entire case, the order could, for example, be an order for dismissal. We filed the case, we've had discovery, we've had the verdict, the jury's come back and said, we don't find that the plaintiff's versions of the facts is actually what happened. We think the defendant isn't liable. They didn't actually commit malpractice. When the court sees that verdict, he's going to enter an order, a judgment order, saying the case is over. At the appellate level, a court will order a lower court's disposition of the case affirmed, or kept in place, or reversed, like undone. So let's say we've got this trial court judgment saying no malpractice. The appellate court could come back and say, yeah, that order's no good. That judgment's no good. We're going to issue our own judgment order reversing the finding and remanding for a new trial. This whole thing starts all over again. So the point I want you to see here is litigated matters get resolved by orders. Every single one. That motion to compel, the court's either going to order that the malpractice doctor turn over that document or order us to refrain from asking for it anymore. But every litigated matter, every trial, every appeal is going to get an order that resolves it. Okay, so now we're ready to talk about what sometimes comes with an order. And in the real world, while a court will always issue an order resolving a case or an issue or a dispute or anything litigated, in some cases, particularly in instances that are really important, the court will also write an opinion that accompanies the order. And an opinion is a written explanation of the legal reasons or the factual reasons why it has ruled on a case or a matter as it has. Now, most often, the courts that issue case opinions are state or federal courts of appeal, state Supreme Courts, or the United States Supreme Court. It's rare for a trial court to issue an opinion with its order unless it's really a hot-button issue and the court knows that it needs to provide a fuller justification for what it did because it's certain to be appealed. The other major exception comes from the federal trial courts. Federal district courts publish opinions fairly frequently just because the issues that they have to decide, the matters that come before those courts, tend to be fairly complex, and a solid explanation of what the court is doing tends to be warranted in those cases. On the other hand, okay, so we've just talked about the real world. We know what a case is, we know what litigation is, we know what a brief is out in the real world, we know what an order is, we know what an opinion is. In law school, a case is shorthand for a case opinion. That document that the court writes out explaining why it ruled as it did on a particular issue. So case reading assigned to you on your syllabus is generally one of those. It is an opinion that a court of appeal or a Supreme Court, either in the state or federal system, wrote. Also, in your case reading, to the extent that you're reading through a treatise, those cases are going to be excerpted. It's not going to be the full text of the opinion. So in the real world, a brief is an argumentative document submitted along with a motion, or if it's an appellate brief of some kind, it is a formal written argument for why the judgment of a trial court or the Court of Appeals should be either upheld or undone. But in law school, a case brief is in fact your personal summary of a case opinion. Since most people don't have photographic memories, it's harder for them to answer professors' questions about a case's details during class without a handy reference of some kind that they can use on the spot to help them navigate where they need to be in the case to answer the professor's particular question. Some of you do have photographic memories, and when the professor is asking you about some detail in the footnotes or in the procedural history, you're not going to have any trouble recalling the answer. But for most of us, smart though we may be, we don't have that kind of recall, and so some kind of handy reference is going to be useful to us. The prototypical case brief is a separate 1 to 2 page document that a law student writes out detailing the key facts, the procedural history, the ultimate issue, the black letter law, any analysis, and the holding recited in the case's text. I'm not going to jump in and give you an in-depth explanation of all those sections of a case opinion and what they really mean, because you're going to get a much better idea of what they mean when we actually jump into our practical examples and analyze a couple cases together. Okay, so just understand that those are the portions of the case that you need to have identified in your case brief let's talk about a couple other issues here. The overall point I want to make here is that the traditional case brief, the idea of writing out all of those features of the case and summarizing them in a separate 1 to 2 page document that you produce, I think writing out traditional case briefs is dumb. I think it's stupid. A written summary is often no more helpful as a memory aid than the case's text itself. Especially at the beginning of law school, you're not actually going to read these cases particularly closely. That's a skill you're going to develop over time. And at the very beginning, you're going to miss all kinds of key details in those sections of the cases, which means that it's not actually going to help you remember or identify the small, ticky little details of the case that your professor's question calls for. They're not going to be reflected there. So you'd be better off to just look at the plain text of the case, at least to start. I also think that the goal in your semester as you're completing your reading is not to write briefs. It's to outline your reading. Outlining is in fact what prepares you for your exam, and briefs can, but they don't necessarily, okay? To the extent that they contribute to your outline, then in my mind, writing them out adds an unnecessary step to the process, because when you do your outline, you're going to be writing all the rules anyway. Why do I need to add this middle step of writing my rules on a separate piece of paper before I incorporate them into my outline? It doesn't make any sense. I would rather just read my case and write my rule summary, right? On the other hand, if I don't do an outline, the mountain of briefs isn't going to help you when you walk into an exam. What you need is an organized body of law, not a 100-page document of random snippets of it not woven together. So just remember that the priority in terms of doing your case reading is to create an outline. The reading is a means to an end, and as such, the briefs are only a means to an end as well. Third reason why I think writing out your case briefs is dumb is it's just not sustainable. If we take it as a given that to enter your exam prepared to annihilate it requires that you keep up with all of your reading and outline every single one of your subjects, then how sustainable do you think it is to do those two things, which are very time-consuming, plus write the equivalent of a, let's just say conservatively, 10 to 20-page term paper every week? If we add up all the cases that you've got to read and brief for class discussion, it's probably in the neighborhood of 20 pages if we assume only one-page briefs. Do you really feel like you've got enough time to do that and outline and read? Personally, I don't find that effort sustainable. And actually, most of the students that I've mentored have just given up writing out full case briefs within a month and a half of starting law school. They just realize this is a waste of time, it's not that effective, and it's a massive time suck to begin with. Okay, so by now you understand that I think the traditional briefing method is dumb. Before I talk to you about my preferred method, which is book briefing, I want to talk to you first about the big picture in law school, okay? And as I think I mentioned before, the priority of doing all your case reading is reading it so that you can put it into an outline. The important thing about a case when you're reading it in your syllabus or your assigned reading or whatever isn't the case itself. It's how to integrate whatever legal proposition that case stands for, which you can't understand without briefing it, into the broader constellation of laws to which it belongs, whether that's torts or contracts or civil procedure, okay? So you have to brief in order to outline, but outlining is the point. Briefing isn't an end unto itself. So whenever you read a case, just answer these 3 main questions and you'll be in a good position to integrate whatever that legal proposition in that case is into the broader corpus of your subject, whether that's torts or whatever else, okay? So answer these 3 questions. Who gets what? What black letter rules did the court recite? And which facts or inferences did it invoke under those rules? As long as you can identify those, the answers to those questions, especially which black letter rules the court recited, you've gone a long way towards being able to incorporate that case into an outline. Pro tip, in terms of identifying who gets what, going through the procedural history is what helps you piece that together where the court is not especially clear about who wins and who gets what. Okay, so if you can answer those 3 questions about a case, then as far as I'm concerned, you're good to incorporate whatever it has to say into your outline. Now let's talk about my preferred method of briefing, book briefing. Book briefing is simple. All it means is that you highlight, according to those sections, the key facts, procedural history, the issue, black letter law, any analysis, and the holding. It means you highlight in a system to identify those things as they appear in your case. Now, it's not going to work to use all one highlighting color, or you're just going to be back to square one with a giant blurb of indistinguishable all yellow highlighted text. Like, that won't help you. You're no better off with a yellow highlighted page than you were with an unhighlighted page. So I recommend you use a color scheme. And I'll tell you what mine is. You don't necessarily have to use the same one. But, I'll admit I like mine pretty well. So I use yellow for the parties, their names, and kind of their role in the transaction. It helps me to understand what the relationship between the parties is. Any facts that support either the plaintiff's or the defendant's arguments or their case, I'll highlight that in yellow. But I don't overdo it on the facts. 1 or 2 really ought to be enough for you to figure out the merits of their respective arguments. Next, you're going to have the procedural history, and I do that in pink. So the trial court, whatever it did, I'll highlight that in pink. The appellate court or the Court of Appeals after it, I'll highlight that in pink. And whatever their judgment was, that's what that gets. The issue I will also do in pink because it tends to turn on procedural issues. Once you've gotten through the procedural history, typically you're going to start to encounter the rules. And as many rules as you find, I would highlight in blue. One thing I would say here is rules tend to cluster, and they may be related but nevertheless distinct enough to where you want to leave yourself a visual cue that that's the case. So what I do when I've got rules that are clumped up in one paragraph or a series of paragraphs and I want to distinguish visually between them all, I might highlight, just straight highlighting in blue, and then underline in blue, and then dotted underline in blue. And if I've got more rules, I'll just start that whole process over again. And that keeps the various rules as I encounter them distinct enough for me to quickly scan when I'm being asked a question by a professor to say, okay, that's the rule he's asking about. Here we go. Once you've done your rules, then the next thing you're going to find is analysis or application. And typically, if the court's ruling depends on factual analysis, and what you're going to find are the inferences that support particular outcomes under those rules. Those I will highlight in orange, and if there are a series of factual applications argued or made by the court, then I'll do the same thing, breaking out those various applications in my highlighting as I do with my rules. In other words, I'll highlight and then underline and then dotted underline for as many different applications or arguments as there are. If it's a case that's really analyzing more of the law, so we have one approach to this issue, another rule that we could use, then I will be highlighting in orange, and what I'll be focusing on will be the rationales, the policy goals of the proposed rules, and which ones the court seems to find most persuasive, which ones it seems to identify internal self-contradictions in, like that kind of stuff. But whether it's factual analysis or legal analysis, I'll highlight both in orange, subject to the convention that I'll break it up, okay? And then finally, whenever I get the holding, whenever the court issues its ultimate declaration about how it's disposing of the matter before it, I'll highlight that in pink as well, because in some ways that echoes its statement of the issue that it articulates. So as we're talking about process here, especially since, and I'm not trying to be patronizing here, but many of you haven't really briefed cases before, and so this is going to be kind of new and unfamiliar territory for you. What I would recommend that you do when you read your cases for the very first time, maybe for as long as the first month of the first semester of law school, I would recommend that you go through the case and that you skim it until you come to the rules section, and then highlight the hell out of every single rule you can find. Once you can look at the rules and see what those are, start over. Start the case over, begin reading from the beginning and thinking to yourself about what the outcome based upon these facts should be under the rules that you've already identified. 9 times out of 10, if you just read the rules and then go back to the beginning of the case, you'll both understand it better and save yourself a lot of time. You're not necessarily going to have to hem and haw over this case trying to figure out what it means when you've got a very clear sense of what the rules are and then start over and read it from the beginning. So, as we said at the very beginning of this video, briefing a case is a skill. It's not just static knowledge. And since that's the case, the best way to learn, for you to learn how to do it, is to practice with a little guidance and feedback as you go. So in the next video, we're going to give you an opportunity to do precisely that, practice. And any links or documents that you'll need will be embedded in the video to which they correspond. We hope you found the discussion so far illuminating, and we'll be back with more content to help you kick law school's ass.
Kick ass.